And we do have one caller on the line right now with a question. So caller, hey, if you're there, go ahead now with your question for Charlie.
Good morning, Charlie.
Good morning.
Hi. I got a house on a rent-to-own, and after 2 years, I discovered on my paperwork it had not been notarized. Is it still binding?
Well, I would think so. I mean, some things aren't binding when they're not sworn to, but in that instance, I think what you've got is you've got a situation where you signed it and they signed it, and I assume, and you've gone on the contract, and the contract's been in effect for 2 years. So the fact that it wasn't notarized, everybody's been living by that contract, doing what it says. So I think you'd be able to enforce it. I mean, I can't guarantee that, but I would think generally, since everybody's performed on it and done it, even though it wasn't notarized, it is a memorandum of what you guys agreed to, even though it's not notarized, and you could probably enforce the contract.
For those who don't understand the notary process, what is the importance of notarization in the notary process?
Well, it makes sure you're the one that signed it, and you read it and you signed it. You swear under oath that you signed the document. That's just that extra step. But if you signed it and you performed on it, even though it's not notarized, it's obviously an agreement between the parties.
Right. I was going to say, is there any sort of legal precedent for how long you're involved in the contract before it becomes legally binding, or does it ever become binding without notarization?
I would think if you entered into it and performed on it for any substantial time, and I'm even talking maybe a couple of months, that's a memorandum of what you agreed to, and that's what was agreed to by the parties.
Okay, as long as everybody continues to play by the rules, it sounds like it's a plan. All right, we do have another caller on the line, so hey, caller, if you're there, go ahead with your question for Charlie.
Okay, my question is, if you have a will, do you have to file it with the local courthouse, or can you just have it in your safety deposit box, or with another party, or with your executor?
Well, I think, and I don't do probate work, so I'm going to have to go out and I always check with an attorney about this that does that kind of work. But I do not think you have to file it. It's probably better to file it so everybody knows where it is. But if you find a will and it's not filed, I think it's still valid as long as it's a valid will and done as it's supposed to be done in the state of Kansas. There are rules about how to do that. Most attorneys don't charge a lot for wills, so people really probably ought to go get a will, at least to get things separated how they want it to be. And sometimes it can avoid taxes, but you've got to have a lot of money to do that, really, where it really affects you. So, but it does give you some peace of mind, and I don't think attorneys charge a lot to do that.
And I'm not sure about this either. I know you don't work in probate court or anything like that with wills, but if someone just writes it on a piece of paper and signs it, is that ever legally binding for something?
Well, it can be in some states. I'm not sure it is in this state. I'd have to check, but I don't think that works in this state.
Okay. All right. Very important information to know if you're writing out a will, and it's something important that a lot of people should think about.
Well, they really ought to just go to an attorney. I mean, it doesn't cost a lot, and it gives you a lot of peace of mind, and the attorney will tell you how to do it.
And helps out your families a lot as well. Thanks so much, Charlie, for being here. Thanks for your calls.